welcome to another episode of PLA with myself and Nick. And we've got today a special guest by the name of Bruce Barkhuizen, who is a head attorney and notary with us here at BSA. Thank you, Bruce, for joining us today and holding it in for Bruno.
Thank you very much for having me, and greetings to all the viewers.
100%. There you go. We've got two questions today, ladies and gentlemen. Both of them do come from our real estate agents that we do work quite in detail with. And then Nick will take the first one, and then Bruce the second one. And then obviously, of course, both gentlemen are welcome to just chip in whenever necessary. The first one, Nick, is basically from one of our estate agents, as I said, and they state that tenants viewed a property and they signed the contract. And they obviously did the ingoing inspection as well. And there are two walls that have some damp, right? And they think that it's because of a pipe that's on the bath, right? But the landlord said he's not going to fix it immediately. And the tenant said that the damp is a health risk, and they actually did not move in, right? But they did put some of their stuff in the property, right? The landlord just then said to them, if they want their money off the rent, they can cancel the lease and move on. So the question is, what should they do in this situation? The lease is in place, but they haven't taken occupation. Is the landlord entitled to the rent? Is there going to be a need to cancel the lease all over again? Gentlemen?
Okay, so it's a fairly straightforward situation. And I think what seems to be the cloudy situation here is because the lease agreement has literally just started. That seems to be why someone might get confused about the situation, because the tenant is partway moving in, they're not fully in the premises from the question. But notwithstanding the fact that haven't fully moved in everything into the particular premises, that itself does not have any bearing on the actual contract that has been entered into between the parties. Okay, so the lease agreement itself, and that's just the agreement between the parties for the lease of this particular property, is already concluded at this point, as far as I can see. Okay, there's a signed lease. The keys, by means of possession of the property, have been handed over to the tenants, and the tenants were in the process of moving into the property. And I think at the start of the question, it said the tenants inspected the property. So they've entered into this particular agreement. They've subsequently found a defect on the property. Okay, in the circumstances, where people might get confused on something like this is because the lease agreement is at such an infant stage. Can the tenant just go, oh no, I now see a defect and I want out of the contract without penalty? And unfortunately, that's not how it works in our law. The contract is concluded between the parties. It is binding. So in the circumstances, if there is a defect in terms of the lease agreement that's concluded between the parties, then the tenant has to act appropriately and demand a proper performance, or, depending on the lease agreement that's concluded between the parties and the Rental Housing Act, obviously, there might be a period of time where they can notify the landlord, and the landlord may have obligations in terms of the lease agreement to actually remedy within a time period, or may not, depending on what the parties have agreed to. But I'm not going to go into particular lease agreements, obviously. It will depend on what agreement the parties have concluded. But certainly, for the purposes of this question, the tenants cannot simply, upon moving in, sit down and go, oh, well, I see a defect that I didn't notice at the time that I inspected the property, and now I want to walk away and not have any obligations in terms of the agreement. That simply doesn't work in law. The tenants will have to, at the very least, demand performance, demand that this defect is remedied if there is an obligation on the landlord, or alternatively, remember, our tenants, in terms of the provisions of Section 14 of the Rental Housing Act, can cancel a lease agreement at any time with 20 business days notice, subject to a reasonable cancellation penalty. So the tenants could, in the circumstances, also do that if they so choose, but certainly they wouldn't be able to walk away without paying anything, and in particular the first month's rent for that particular property, if that property has been handed over to the tenants for their use. The landlord's position, although he stated it quite bluntly in the question, the landlord's position is in fact correct. The tenants can cancel, but certainly they're not going to get a reduction from rental as a result of this. They will most likely be liable for a reasonable cancellation penalty in terms of the Rental Housing Act.
Awesome. Thanks, Nick. And Bruce, because we have you here, of course, I must make as much use of you as possible. I'll take advantage, and perhaps you can just quickly add a word to that question before we move on to the second one.
I actually agree with what Nick has actually mentioned, and that is the position. The Consumer Protection Act absolutely affords the landlord the right to claim a reasonable cancellation penalty. The tenant won't be able to avoid that in consequence. And in fact, the landlord may even claim and assert that the tenant's actually in breach of the lease agreement by refusing to take occupation. Most lease agreements have a term to the effect that you may not depart with occupation, save or otherwise is provided for in the lease agreement. But I do want to focus in on the landlord's obligations, and especially in the unfair practices regulations of Gauteng in particular, that it is the landlord's obligation to maintain the plumbing and sanitation installations. It does not speak of mold, and merely says that the systems must be in good working order. So as for the mold, if that is a health risk, obviously the tenants would have to avert and prove that. I do imagine that would be rather difficult, and hence the landlord would be in a better position in terms of power should litigation ensue.
100%. Well, there you have it. They have it to our viewers. Thank you, gentlemen, for fully covering that question. Once again, contracts do become binding once you sign them, if of course they're lawful, and one cannot just walk away just because they feel like they're just not happy and they don't want to be part of it anymore. There will always be consequences to that. So do read the contracts, do understand your obligations, your rights and responsibilities, and look of way to obviously amicably remedy those. And then we are now going to